Good afternoon, South Florida. This is Matt Rocco from the South Florida Manufacturers Association, president of the SFMA, and we are a regional trade association that is all about serving manufacturers, helping them get better what they do, helping them with efficiencies and best practices, and bringing our community together. And we have an excellent podcast session for you today on patents and the journey of one of South Florida's premier manufacturers. We have Mike Heissenberg from Expert Shutters, who's the owner and CEO of Expert Shutters, who was a 2019 South Florida Manufacturer of the Year winner and also was a finalist at the statewide level at the Sterling Conference. So thank you. Welcome, Mike. And Mike has completely just revamped his processes and has taken his company from where he was and where he really wanted to be. And no doubt that he has gone through patents, and it's just amazing. And we'll have Mike share a little bit about his company, but just amazing what they have done and the advancements they have made since they have joined the South Florida Manufacturers. They've really become a leader in their industry. So I would definitely check them out, Expert Shutters, in St. Lucie, Florida. And thank you, John Rizvi, who is the patent professor from the Patent Professor in Coral Springs, one of our other outstanding members who have engaged with us over the last year and are really looking to ramp up and do some high-level work with our community, especially our manufacturers, as you are either in the process of patenting or thinking about maybe patenting or just having general knowledge. I think today is going to be an excellent session to learn from one of our members, one of our manufacturers in the community. So thank you to both John and Mike for taking the time today, and I'm really looking forward to hearing your story, Mike. And John, I'll turn it over to you now, and if you want to continue from here.
Okay, yeah, terrific, Matt. And Mike, it's so wonderful to hear the stories behind innovation and patenting. So my start was at a large corporate, a huge patent law firm in New York City, and I speak with some of the attorneys there. And they never get to meet with inventors directly, right? They're dealing with lawyers and MBAs, and it's so far removed from the creative spark of that new idea. And that's what fuels my passion. So I love the fact that we're going to get to hear about your journey with patents, and not as a lawyer acquiring or merging with another company and getting their patents, but as the catalyst behind the innovation. So with that, why don't you start just wherever you want, some background on yourself, on your first introduction to patents, and what has your company done in terms of protecting what they have.
Okay. Well, we first got involved in patents when we were working on development back in 2003. It was for a new accordion shutter system. And we had developed some very unique characteristics of the product, and we were curious as to how we could protect that intellectual property. So we began our journey and started to seek help from a patent attorney. And we found it very difficult at first to navigate the process. Patent process is somewhat difficult in some cases, especially if you're working with products that have a lot of patents surrounding them already. It's difficult to find something unique that you're designing, you're inventing, that you can find a solid patent on. And what we found was that we would come in with very strong language initially, and then as we went through the process, in some cases we had to soften that language or change the language in order to navigate other patents that might already be in existence. And in some cases, they didn't even pertain to the same products that we were developing, but they were patents on similar products or similar apparatuses, if you will, that blocked us, if you will, from moving forward on a particular patent. And since then, I think we're up to 33 or 34 patents. We've got about 5 more in the mix right now. We're in the process of developing yet another new product. And it's exciting when you can see it, something that you develop and something that if you're find something unique that you've been able to incorporate into one of your products, and to be able to take it to the patent office and see the process. We actually got to go to Alexander, to the patent office for one of our patents because we had such a difficult time getting it through. We ended up sitting down with the patent examiner and our patent attorney, and it was just a small change that we ended up making, but it was in the misunderstanding of the language. So when you're talking, as my patent attorney says, patentese, which is a different language than the rest of us speak, it can be sometimes difficult to navigate, but it's exciting. It's very interesting, and we've done very well. We have patents which govern several products that we've developed in our manufacturing. We also have some international patents that we now have. In Europe, we have 6 companies, 2 in England, 2 in Germany, and 2 in France, that are actually manufacturing a product that we developed, and we're patent protected. So it's pretty cool in that aspect as well. So I'll turn it back over to you.
Yeah, so it's funny you mentioned that sometimes it's a little change. That's all the examiner is requesting. We have at my law firm, we have 4 former patent examiners, so we get a lot of insight on how they look at claims and what they approve. I'll kind of try and draw a chart here that kind of illustrate what you likely experienced in prosecution. So when we draft patents, you can think of it like almost an upside down pyramid in terms of how broad protection we're seeking. So you start really broad, and that's what every patent attorney hopes to get for their client, like the most protection possible. And then you draft a bunch of claims. I don't know if you remember how many claims you've originally filed, but it's typical to file 20 claims with your patent. That's what's included with the payment. And you can think of each claim as a bullet. And all it takes is one of those bullets have to hit, and the examiner is not able to find an invention, and you get your patent. So you start like really broad. Like, to use an example, the first, if your idea is a chair with magnets for pain relief, you would just have a broad description, like maybe even not even limited to a chair. Just say a surface for supporting an individual with magnets for pain relief. And if the examiner finds that, bam, he's going to reject that claim. So then you go a little bit narrower and you say, okay, he didn't like, somebody's got a flat surface out there, maybe it's a mattress or whatever. Here you say a chair having magnets therein. And if the examiner finds that, bam, it's dead. So then you go a little narrower and you say, well, no one has a heated chair with magnets. And if that's not found by the examiner, bam, then that's your invention. Then you have exclusive rights to a chair with heated magnets in it for pain relief, or a chair with magnets and some way of heating it, and then you've got it. And if they find that, then you keep going down. What you don't want is, at some point, the claims might end up being so narrow that they don't provide a manufacturer with really useful protection. Like, for example, if we end up getting protection for a chair that has sidearms, now a competitor can use a bar stool and get the heart of the invention. If you're forced to put things like 4 legs in the chair, then somebody could have a 3-legged chair and get around your right. So it's this, and for inventors, it's frustrating because it's this high stakes game of vocabulary almost. It's like a game of Scrabble, except it's no fun, because when this ball is being passed back and forth between the patent office and the lawyer, the clients feel like, okay, this is great for you guys. The patent examiner is paid with taxpayer money and governmental fees for filing. The lawyer is paid by the inventor for putting on this battle. And every time the ball goes back and forth, the inventor has to pay additional funds for this battle. So I don't know what approach has been used in the past. What we have found really helpful is to try to get the patent examiners at the patent office on the phone. And it's an amazing system that we have an ability to do as patent attorneys that other attorneys don't have. We can speak to the examiner and suggest changes before we formally make them. And I speak to other attorneys and they're like, you're so they're so envious because they're like, you know what we would give to be able to call the judge and say, hey, judge, we want to argue the alibi that my client was not at the movie theater that day. What do you think? And the judge can tell you, oh, you know what? I think that's a decent argument. Go ahead and make it in court tomorrow. That just doesn't exist. But as patent lawyers, we have this ability to speak to the examiner and say, I think our client's invention is different because, to use your shutter example, like whatever, we add titanium to certain components and we think that's unique. What do you think? And the patent examiner might say, hey, wow, that seems unique. Go ahead and submit. So anyway, that's one of the things. I've been practicing 25 years. One of the tricks that we find to be able to get allowed claims, and it really helps to have a former examiner on the phone, somebody that's worked at the patent office. So it's like, hey, and so the examiner knows they're dealing with an expert who's had their job before, who used to do what they do. And then we find that helps shorten the prosecution. Like there's nothing harder. And believe it or not, even as attorneys, it's really painful to see this tennis match of sorts between the patent office and us as the attorneys, especially if your client's not Microsoft or Apple or Google, and it's a company that's especially that's why I love the South Florida Manufacturers Association. These are companies that are providing jobs to South Florida. Many of them, the founders the inventors are in the company. They have the need for this funding for marketing, for R&D, for new products. They need it for payroll. They don't have stockholder funds that are funding this litigation. So anyway, I think I don't know if I've pressed on any pain points, but that's with 36 patents. I'm sure you're not new to this ping pong match, table tennis match, whatever it is, back and forth with the examiner. Tell us a little bit about your experiences during it and how it was from your end as a client. And has it improved over the years from 2003 when you had this first experience with probably your first rejections versus now? Do you take them more in stride and you're like, okay, this is par for the course, they always get rejected?
Yeah, well, we do more homework up front now than we used to. We used to, throw it at the wall and see if it would stick before we did much legwork, and now we look into it pretty deep. In fact, a couple of times we've seen things that might block, and then we have our patent attorney actually do investigate it further and give us analysis before we even begin the patent process, just to know if we're on the right track or not before we spend a lot of time and effort with it. The time we went to the patent office with my patent attorney, we went back and forth several times with the patent office, and the rejections that we kept getting didn't make sense to us. And it was because we didn't have direct communication with them. The moment we sat down with them, it became very clear we were looking at something and describing in a linear to us, we were describing something that was linear in the length of the extrusion, and they were looking at the profile and looking at it linear as if it was the height of the extrusion. And so that little bit of misunderstanding caused us to take a trip to the patent office and spend a lot of money and time doing it. Whereas I really love your approach to, let's make direct contact and have a quick conversation. It's kind of like when you're texting and it's very frustrating because you don't get the full meaning or the full content. And it's like, sometimes I'm texting someone, I go, can you just pick up the phone? We'll have a conversation. We'll get this over with. And so I love your approach to trying to reach out to the patent examiner directly. That saves a lot of time and effort. For anybody that's getting involved, I would, and looking at patenting something, I would definitely find a great patent attorney like yourself. And then I would do as much research ahead of time to get to understand what it is that you're getting into, and then have correct expectations. You likely are going to get some rejections. Like you explained all of the claims, and you try to put as broad as you possibly can. And then those claims do get narrowed down as you move forward with the patent, and you hopefully come out with something that really has good meaning to it that will help protect your intellectual property. So it's best to have good expectations. I know that one of the patents that we put in, and to me it was one of the simplest ones we put in. It was just for a small snap cover kind of a thing, you know. And this is back in the day when we actually got paper back. We don't get paper anymore; it's all digital.
Right,
But
right.
we got a stack of items that the patent examiner compared it to, and I'm not exaggerating, it was 4 or 5 inches thick stack. It was bigger than a phone book of paperwork come back from them of things that they found were similar, that we had to kind of navigate through and change our claims to avoid this gigantic stack of other patents, if you will. So, you know, having the right patent attorney, having drawing your claims out as broad as you can and as thorough as you can and as to the point as you possibly can, you're going to save a lot of trouble and a lot of time on the far end. I also, we are actually applied for one of our first design patents. And that was an attempt really just to, based on the component, it seemed to make better sense to go in as a design instead of utility. And it's our first one that we're trying to go that direction. And so not every patent fits what you're trying to do. So again, having a good patent attorney to advise you and point you in the right direction, where, you know, this may not be best suited for this type of patent. And then there's also times when you want to consider whether you're going to take it international or keep it domestic, whether it's going to be published or not published, things of that nature, while you're still working on it, trying to see if it's patentable, that idea, you know, whether, so if you want to go international, it's going to be published. And so everybody and anybody can see your idea, it's going to be out there. And then you may not achieve patent, and then you just published your idea basically for anybody that's interested. Whereas if you decide to stay domestically, it's not published. So you have time to work on it and kind of work through the process and not have to air it to the world, if you will. So there's a lot of pros and cons to the process. And that's why good legal advice is really important, having the right person in your corner. So.
Yeah, so with the amount of patents that you have, I mean, I think, have you seen a difference in your own, like, I mean, I kind of feel the way you seem to have a grasp of this, almost like I'm speaking to another patent attorney, because you go through 36 patents, which likely means about 70 at least rejections. That's a lot of experience. It would, even a first year, it would take a lawyer that's exclusively working in patent law, working 2-3 years to get that amount of experience. So do you think that has helped you, or has it hindered you in some way?
It's helped tremendously. So when we do get the rejections, and keep in mind, again, some of these are international. So now we not only have the patentees that we're speaking, but we're speaking other languages in patentees. So it becomes even more confusing and difficult. But yes, the more experience you develop with it, the more comfortable you are with it. And I think the more success you'll have at it. You know, when you go your first 1 or 2 patents, it seems like a big deal, and it seems like such a long drawn out process. And after you go through it a couple of times, you understand this process is going to take a couple of 3 years before we reach resolution with it. You know, so it's not something where you're going to, you know, throw it in the patent off, throw your patent in there, and then within a week get an answer back. You know, it's going to take a lot of time. And that's why it's important to really be thorough with that application and make sure it's as complete as you can possibly get it, because it's hard. It's hard once you get started in the process to make those revisions or try to change the claims if necessary. So you want to try to lock it down as much as you can right from the start.
That's all really helpful. You mentioned even in terms of your experience helping you, that you now don't just throw something against the wall to see if it sticks, but you do preliminary research. Now patent attorneys do what's called a patent search to make sure that there aren't other patents out there but I have a lot of clients that are experienced at patenting, and they have some sort of system that they go through before we even see the idea. Have you gotten to the point where you're doing some internal evaluation before it gets to a patent attorney?
Yeah, absolutely. Because in some cases, because we do have a lot of patents, people that know me often approach me and say, "Hey, Mike, I've got this fantastic idea," and they describe it to me, in confidence, and I'll say, "Well, hold on one second," and I'll Google it, and I can pull up. It's already in the market somewhere. I go, "Well, they're already selling this, so you patenting this is impossible at this point, unless you come up with some variation to this that might be patentable." But just simple Google searches sometimes will kind of lead you to whether or not the product is out there already or similar products, and then you can do a little bit more research on your own. But that's kind of the preliminary side of it. But really, the patent attorneys where we have the greatest level of confidence for him doing a search and being able to look at it objectively, because he's got better insight as to what might prevent us from achieving patent or not. Some things that we've presented to our patent attorney, he'll look at and say, "This is going to be a rough go here. There's a lot of interference here that we could run into here." And other stuff we bring to him, he says, "This is clean. I'm not finding anything in our searches that might prevent us from moving forward with this." So it gives us a good idea right up front whether the path is clear or not.
Okay, and that's helpful. A lot of times I find, there's still a dichotomy between like business distinctions and business advantages to a new product versus patentable distinctions and patentable advantages. So it takes some of our clients, it has taken them some time to realize that, okay, they might have something new and it provides, and maybe it's less expensive, or maybe something about it makes it disposable. And we get those arguments for distinctions, and it's hard for them to see that the fact that something is disposable is not, from a patent examiner standpoint, it's not really a strong distinction. They're like, how could that not be a strong distinction? Look at how much better it is to have this part or this piece be disposable. But the patent office's take really does not look at financial considerations, the examiner. So the fact that you can make a product for less money than your competitors, you have to be able to point to some structural reason why it's less money. It can't just be that you found better suppliers, you found maybe you improved the process, but otherwise lower cost is not a strong reason for patentability. Higher quality is not a strong reason for patentability. But in the business world, both of these are phenomenal reasons. Like if you can sell a higher quality product at a lower price, you're golden in the business, in the market. But as far as patentability, a higher quality product at a lower price, they're like, right? That's great, yeah, but what can we do? And then, some examiners have the view that, okay, anything is disposable. I mean, the people like billionaires, they can have single-use coffee mugs. Like they could buy a real, whatever, it's disposable to them. And then it just comes down to cost. So have you had instances where you see huge differences in a new improvement, and you go to, and you do your searches, you don't find it, you go to a patent attorney and they're like, meh, that's not enough?
Yeah, no, it's some out of the 30 plus what we have, there was probably, I would say, 3 or 4 along the way that we started down that process and then saw that there was just so much interference that we just kind of dropped it, because it would have probably taken years and tens of thousands of dollars to get even some of the claims to stick. And at the end of the day, if it's too watered down, if the claims are too watered down, it may not be worth the effort. But if you can develop products that are better and less expensive and can patent a process or an element of what you're doing, then you got a home run, because now you've got a advantage in the market, but you also have some protection from the rest of the industry taking that idea and just incorporating it into their products. So it's very important. The patent process to us is very, very important. And nowadays when we start, now we do a lot of 3D printing, we do a lot of R&D, but we keep getting a little bit better at what we're doing. And we're also getting better at identifying, is this patentable or not? Should we even attempt to patent this idea? And so as the new ideas flow out, it really becomes very interesting, because it's like, and to be honest with you, recently we're developing this new product, and we've got about 4 or 5 patents surrounding it already. And one of the items that I talked about, the design patent, it was, we didn't come up with the idea ourselves originally, if you will. It was taken from the interior shading industry. Has something very similar to what we developed with our product. And I said, well, this is something we're simply adapting to our market. So I don't see it being patentable. Somebody's already come up with the idea. It's already in the market in a different industry. And the patent attorney said, oh, absolutely. I think that this is something that a design patent would work really well on, just to kind of keep people from mimicking what you've done, copying the design verbatim. Even though it's not a true patent on the concept of it, it's a design patent. This will keep people from just Xeroxing it, if you will. And I thought it was a great idea, but I didn't really feel that we even had a shot at any type of patent. And just having patent pending on it is going to help keep the wolves away a little bit, at least for a little while. So it's all great stuff to keep your ideas your own. For example, so the accordion shutter that I started to talk to you about at the beginning of the conversation, we patented that in 2003. So we're coming up on the end of our patent actually on that. The product has been the #1 selling accordion shutter in the United States for over 20 years running now. And so we had that protection for that whole duration, and it's amazing. And it led us to develop new products and new ideas. So I encourage anybody that's, you're developing products, you're looking at innovative new ideas, take the time, make sure that you're protecting yourself for sure.
And one of the things you mentioned is having given up on pursuing some patents, not because you didn't think you could ultimately obtain a patent, but because what you're going to obtain, you didn't see it as being as valuable, like pulling up, just so you know, you guys don't, well, I'm not the illustrator at my firm, so just don't judge us based on the drawing ability. But suppose you get one of the final, most narrowest claims, like claim 19 or 20, and a patent attorney feels that he would be able to obtain them. Remember, like even the best patent attorneys do not really know your business and what provides a competitive advantage in the business. So what is really the sweet spot is a mix of business knowledge with intellectual property knowledge. So it's best for the manufacturer, the inventor, to explain, this narrowing, is it going to provide a real advantage in the marketplace? Because if not, then there's no benefit to pursuing it. Like going back to that chair example, if there's some benefit to the chair having 4 legs over 3, and everybody wants a 4-legged chair instead of a 3-legged bar stool, and the other features being the same, like magnets and a way to heat it, then it's worthwhile. Even though it's one of the narrowest claims, you can tell your patent attorney, go for it, get me the patent on the 4-legged chair that does all of this, because there's people that really want that. They have a preference for it. It gives us a competitive advantage. But if the real marketplace, and your competitive marketplace better than any patent attorney ever will, and if you say, you know what, end users and builders and contractors, they don't care whether there's titanium in the shutter or not. Like, just to make up an example, yes, can you get me a patent that has titanium in it? Maybe you can, but it's of no economic value to us, because we'll be the only ones able to produce a shutter with titanium in it But so what? Nobody cares for that. Nobody wants it. Maybe it provides some advantage in a scientific standpoint, but if that advantage doesn't translate to what actual buyers want, then it's useless. And the best examples are, there are so many patents on, I don't know if there's been studies that our current keyboards are not ergonomic, right? They're made for back when typewriters had real keys that would swing out, and the placement of the keys on a keyboard are not scientifically done for the vowels and consonants that are most commonly used. They're just done so that the K key doesn't swing and hit the L key or whatever. Like, that's what it's based on. And there are thousands of patents on improvements to the keyboard. And are they scientifically an improved keyboard? 100%. Like, it can do surveys, they can do tests of somebody that's taken the time to learn this keyboard that can type the pants off anybody else using this improved device. But now it comes to the real market and what consumers want. Nobody wants to learn a different keyboard with a different set of keys. Like, no one in the world wants to do that. And if you're a business and you have to decide on buying equipment for staff, for your secretaries, paralegals, whatever, there's no one that, they're like, I don't care how much more efficient your keyboard is and how many scientific studies prove your keyboard's better. I live in the real world. I have to put my ad on Indeed like everybody else and get applicants. And I don't want to pay for 6 weeks of somebody hunting and pecking on your super improved keyboard. So that's the reality. That's what makes it such a tough job to get a patent that gives you meaningful protection from an intellectual property standpoint, but also that gives the client what they ultimately want. They don't want a
patent. Got to be marketable. It's got to be commercially viable. It's got to be marketable. I could be wrong on my statistics, but I think the guy that invented the Super Soaker in his basement, that was about his 300th invention before he finally hit it right. And if I understand correctly, that there's, out of all the patents that go into the patent office, there's only a certain percentage that come out successful. So you have to understand that, there's a lot of ideas floating around, and a lot of times if you have an idea, there's good probability someone else also had that idea. So it's hard to find those, very unique ideas that no one else has come up with yet. I know that during some of our patent applications and through the process, we were getting compared to ideas and patents that came out in the early 1900s. I can't believe that we're comparing this to something that somebody came up with, over 100 years ago, and probably never got to be commercially viable either. It was just an idea that they patented it, and now we're being blocked by this patent from 100 years ago. So you just got to navigate it correctly. I hate to cut short, but I've got a meeting coming up in just a minute here, and I can see through my conference room windows here. They're already piling into the showroom waiting for me. So
okay, no, we're good. I just before we end, I just want to give you an opportunity. If there's one thing you would tell your younger self about patenting, or other manufacturers that are just starting, one piece of advice, and we'll end with that, and I'll let you get on to your meeting. Like, what would you tell them?
I'd say don't hesitate. Figure it out. Get to a patent attorney that you trust and get it moving. Don't wait. The longer you wait, the more opportunity that opportunity might slip away. So don't wait. Don't hesitate. Jump in with both feet. Get going on it, and be prepared for some rejections along the way. Be prepared. Be patient, but do it. Get out there and get it done.
Terrific, Mike. It's been such a pleasure. Thank you for joining us today.
Thank you so much. It was a pleasure to meet you.